Welcome to the only Mel Cruz show, the We On Your Head podcast. Discussing topics that make you say, how and where can we improve as a society? From a Black American's perspective. Copyright disclaimer regarding fair use is in full effect. The views and opinions expressed in this show, you guessed it, they're all mine. Catch us live, be ready to speak. This is a call-in show. Be sure to hit the like button, share, subscribe, replay gang, leave a comment. You know I want to hear from you. Let's go to work. Okay, so we're live and we are in the mix. Read the description if you want to know what this video is all about. Gang, the Twitter gang is here. This is what we do. We just haven't done it as a group in a while, but we hear Neil. And we're discussing the Supreme Court oral argument, and we're necessarily breaking down Janiyah Nelson. I'm calling her an NAACP attorney, but Black is correcting me and said that she's the legal defense. So we'll get the exact particulars. But Black was already up. He's got the mic. We in this thing. Yes, go right.
Right before Black goes, and shout out to the only Mel Cruz and the We On Your Head podcast.
Your head.
For connecting and joining the top of the hour. Episode 3 topic with relevant.
There it goes.
Supreme Court versus Louisiana redistricting. And I want to definitely put it out there. It's a group of non-Black voters who are suing to challenge the creation of a second Black majority congressional district, and a group of Black voters, the NAACP Louisiana State Conference and the Power Coalition for Equity and Justice, who are defending the need for that district. And I want to lay that on the line. Shout out to the family. Let's get it.
All right, let's get it. And joining is Professor, straight up off of Twitter as well. Professor, I didn't know if you want to be camera on, camera down. I got my camera off. I'm looking so good that I can't put my camera on because it'd just be a problem for everybody. You understand what I'm saying? But welcome to this side of it. Thanks for being here because you can help us out on this side too. So, Black, you had your hand up. Go ahead.
Yeah, shout out. So I'm glad that Mr. Rella was able to go and get the specific case because I felt like it was a Louisiana state, but they always will put up it's a group of affected voters, and all of that. And they're probably Republican Party operatives, but Jasmine Crockett, I'm looking at her district. This is back in August, so they did, as you mentioned, Texas, they redrew her district to essentially make it so that she cannot win that district. And so she's looking at a Senate run, and I don't know, the state of Texas, she's got to win a statewide election. That may make it very, very hard for her, but apparently they have redistricted her out. They have gerrymandered her out. And so that argument that they made earlier about an incumbent and a traditional map crawling, it just goes out the water because in real time they just redrew her out of her district.
Yeah.
She's the incumbent.
While sitting in office. And that's in and of itself disrespectful. And they said this is what they were going to do. So, how you like them apples?
And this is where I'm going to repeat what I said earlier. If she had filed her declaratory status in court as an attorney and sued against the redistricting, because at that point, she, as a representative, would become a minority, and she could argue that race was a factor because the representatives in the nearby cities are majority X. The reason why the descendants always wins in the United States is because the Constitution and state's Constitution support our ability to claim sovereignty and consent. The moment we realize our authority lies in the way we weaponize literally our knowledge of information, law, and the protection repercussions for ourselves. It will change the game.
So, Rella, here's the thing. It would be awesome if you could break down in a very succinct manner. Yeah, this is your show. We are top of the hour, episode 3, relevant hashtag versus what is this? The Supreme Court versus the Louisiana redistricting case. And so, what you're talking about is a whole different, heavily detailed activity. And I don't know if you think now, if it'll be distracting based on what we're talking about now in terms of this Supreme Court oral argument. But when you reference this work that you've done, this body of work that you've created, it's new. And so a lot of people, you might mention it, but hell, guess what, girl? We don't know the details of what you're referencing. And so it makes it hard for us to say yay or nay, or even finish the follow through with your statement. Are you able to succinctly give us an overview, and we get back into this Supreme Court?
Yeah, and I will tie it back in. I will tie it back in really quickly because, again, I appreciate, this is the reason why I appreciate the only Mel Cruz, because you be on our head.
Well, baby.
And let me tell you, it is so relevant. And the reason why it's relevant because it will help to get people to wanting to ask more questions about, hey, what is a declaratory certification, and what would that do for an injunction? So, the states recognize declaratory statuses, and they recognize, and a judge can actually, approve a declaratory judgment. So, for us, declaring our status as descendants and a harmed party, meeting the controversy laws or claims in order to file a case, because everything that's going on in our nation right now surrounding redistricting, surrounding discrimination, we fall into those areas of harm. So if you file your declaratory status, the states have to recognize you. You are now invoking your constitutional rights under the consent of your sovereignty. Your sovereignty as a U.S. citizen. That is something that descendants should do immediately. Whether you are running for office, you're not in office, you're just a regular 9-to-5 citizen, or you are a millionaire, whatever, you want to go ahead and get that done immediately. Because now, if you are going to go ahead and file suit against a party or someone who has contributed to or is a continuation of contributing to harm, you now have a case. And that case will be heard in such a different way, and I think an expedient way, in my opinion, because of the simple fact of all the cases that have been presented by the Solicitor Generals from New Jersey to now we have Louisiana, and then we have the U.S. Solicitor General who is bringing the case of the birthright citizenship, based on Trump's revision version of it. And so now we, as descendants, can say, no, hey, we are the people, and we're being recognized for these things that are happening. If the people in Louisiana and the population said, hey, we all are filing our declaratory certifications, and based on this case, well, we're not talking about race anymore. Now you're actually talking about U.S. citizens who are by states recognized under the terms of black or whatever, X, Y, Z, all the terminology that's floating around in, social media. We now are covered under law. You're now actually invoking your true representation under the law. So state state identifiers and federal identifier, and that to me is a smoking gun.
Okay, so, quick question. Yeah, I mean that's good. I'll be honest with you. I'll probably ask you that question a few more times before it's all said and done. But quick question: have any cases been brought to court at all? Have any of these cases been argued in front of a?
No.
Okay.
Come on for the declaratory status?
Yes, ma'am.
No.
Yes, ma'am. Okay.
No, because it's new.
Okay. All right. Awesome. I just wanted to get that. Like I said, this is brand new. It's a brand new body of work. So questions abound. So.
No, I will give it your program.
Okay. So, and ladies and gentlemen, yeah. Okay. Thank you. Great one. Let's get back into it. I took it all the way back. No. Okay, you know what? That's it, bro. I tried to tell you before we went here. You're going back down. You're going down, babe. You're going all the way down. We thank you. You know, listen. I'm beautiful, even when I'm ugly. How about that? Damn. That's Al Pacino. I always tell the truth, even when I lie. But what you're not going to do, great one, you're not just going to call me a nigga like that. I don't know you, man. Right? So, anyway, I rolled this back, Rella, to the beginning of Justice Alito and Janiyah Nelson. And so we'll hear that exchange again. Shout out to the professor for being on deck. You the guy, Professor. Thank you, sir.
Thank you for inviting me up in here.
Yes.
And look, let me say this right quick, if that's okay, Mel.
Absolutely.
I'm not against Jasmine Crockett, at least personally, because I do think she does make a stand against these Republicans.
Mm-hmm.
She does that.
Mm-hmm.
My only thing is, I just don't see her doing enough to try to fight for Black America.
Mm-hmm.
And that's why I can't stand with her.
Mm-hmm.
So when they did go in there and change her district, I really didn't feel anything for her regarding that, because she's not doing anything to help us anyway.
I don't disagree with you, Professor. I really don't disagree with you one bit. But you know, she is growing on me though, because when she does get in there and argue, she makes some good arguments. But you know what? We'll bring that up on another one, because we on top of the hour, episode 3, topic relevant: Supreme Court versus Louisiana redistricting case. Let's get back to Justice Alito and Janiyah Nelson.
Wait a minute, we got Black majority.
Oh yes, Black. Absolutely. Yeah, Black.
Yeah, I want to build on what Professor said. So,
okay,
if she's going to run for Senate, right? There's 4 million Black Americans in that state. Probably half are voter eligible. That means she's going to have to run hard to the Mexicans. So, if she does run for Senate, expect her to run hard for that Mexican vote, because that's the only way she's going. You know, she's a Democrat representative, so she's going to get Democrats that are white down there, but she's going to need those Mexicans. So that's all. Well,
you know, and that's a good point there, Black. And let me ask you this question. Do you think that because of the way the immigration situation has been going on, the way ICE has been doing, you know, these Latinos, do you think possibly that they might be encouraged, that those Mexicans might be encouraged to vote for her just solely because of how Trump has backstabbed the Latinos?
Well, two things are happening. Abbott turns out next year in that election, so they won't have to deal with him. And then, like you said, if she is essentially saying that she's going to be some sort of protectorate over that population, separation of families, children. I mean, there's so much videotape to go around. She could have endless campaign ads just based on ICE interaction in the country.
Ain't that it?
So it could wait. I mean, it would be logical from a political perspective to use that population in that way. So yeah.
Okay. And so I do have just a little bit of background information, because it's just so important. Janiyah Nelson, I believe that's how you're pronouncing her name. Beautiful Black woman, and look, doing the work for real. I just got this off the website. It's Janiyah Nelson is president and director counsel of the NAACP Legal Defense Fund, the nation's premier civil rights law organization fighting for racial justice and equality. The Legal Defense Fund was founded in 1940 by legendary civil rights lawyer and the nation's first Black Supreme Court Justice, Thurgood Marshall, and became a separate organization from the NAACP in 1957. The lawyers at the Legal Defense Fund developed and executed the legal strategy that led to the Supreme Court's landmark decision in Brown versus Board of Education, widely regarded as the most transformative and monumental legal decision of the 20th century. Now, here we have this young Black woman who praise God that, you know, her health remains and this, that, and 2/3, and her physical safety is protected. She can take us all the way to the bank, because right now she's killing the game in her argument, in her legal acumen, and she's clearly unintimidated by any of these Supreme Court justices that she's arguing in front of. So if y'all are ready, I'll go ahead and hit play and we can finish listening to this discussion. Y'all ready? Here we go. Here we go.
Race, or whether race overwhelmingly prefer one of the political parties, does that transform the situation into racial voting, or is it still just partisan voting?
No, you look at how different races of voters vote and whether they vote in a way that is polarized. And the Jingles test requires us to look not only at that, but a number of other features as part of the totality of the circumstances test that suggest that race is playing a role to contaminate the electoral process and submerge minority votes in a way that violates the Constitution. So party cannot explain away a racially polarized circumstance unless we look at the totality of the circumstances. And I will say, in Robinson, for example, the court entertained testimony along those lines, as it did in Milligan, and found that it wasn't credible, that the extreme racially polarized voting that we have in the state of Louisiana cannot be explained away by party. We're talking about racially polarized voting that is above 84%, which is more than what this court found in Thornburg versus Jingles in 1986, when the numbers were 70%.
That could be easily analyzed by statistics to see whether whether white Democrats vote for black Democratic candidates at a lower rate than they do for white Democratic candidates, whether white Republicans vote for black Republican candidates at a lower rate than they do for white candidates. It's easy to isolate race from that to see whether there really is racially polarized voting as opposed to partisan polarized voting.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Can you comment on the Solicitor General's suggestion at page 25 of its brief that the court should hold that plaintiff's illustrative district cannot disregard the state's political objectives, and goes on to say Section 2 plaintiffs cannot claim a lack of equal openness where politics rather than race is the likely reason for the state's refusal to create a majority-minority district?
Yes, that suggestion would swallow Section 2 whole. As I said, party cannot trump the responsibility of states to ensure that all voters have an equally open electoral process. The fact that black voters may correlate with voting Democrat or white voters may correlate with voting Republican does not deny the fact that there is racially polarized voting, and the totality of the circumstances, including the inability to elect black candidates in Louisiana on a statewide basis for a number of offices. There's never been a black person in Louisiana elected statewide, is additional indicia that race is playing an outsized role in the electoral process in Louisiana. And so the idea that you have to show that a party, is the reason for the racially polarized voting would eclipse the entire Section 2 analysis, which is focused on ferreting out and ending race discrimination in the political process.
You've said several times that it's playing an outsized role. What's the proper size? In other words, is that wiggle room we're talking about, or a significant percentage? What is meant by outsized?
So this court has held for a long time, beginning in Shaw and in many cases since, that there's always an awareness of race. There are always racial considerations and even race consciousness in the districting process. What becomes potentially unlawful is when race is the motivating factor. That's what Miller versus Johnson taught us. That's what Milligan reaffirmed, that the line between the appropriate use of race and the use of race that will get us into the strict scrutiny territory is the dividing line between motivation and general awareness. And what I'm explaining here is that when voters are blocked by a white bloc vote that is so substantial that it usually overrides the politically cohesive vote of black voters, then we have at least a prima facie case of vote dilution. And then the court is asked to consider the totality of the circumstances.
Okay, I think we need to stop it right there real quick because I feel like she, come on, because I think she just broke it down in terms of, she described with all clarity what this Louisiana argument is about, but she also described in all clarity what is going on, what Texas did. And so,
and she even mentioned the fact that even with white voters being a minority, they still weaponize the political side of things to actually redistrict the line so that they get a majority seat and become representatives over even a state like Louisiana, where they are the representatives and they are not allowing black representatives to get into higher positions to control a state.
Right. Because in essence, there should naturally be a larger number of, and I'm not even going to say, because I do like how they are making it clear that it's not about race, because it's not like we couldn't get, and I hate to make this statement because right now in this day and age, in this political atmosphere, this is not a true statement right now. But, back when Clinton was running, this would have been a true statement. But it's not like every person that a black American would vote for would actually be a black person. So you could have somebody in Louisiana that would not be black American, but would be of the sound mind and body.
Like Winsome Sears?
Well, no. Because where I'm going with is they may not be black skin-wise, but they would be in that majority district that is majority black. Because let me try to be very succinct. You have Louisiana, large state, more diversity than the clear people, but somehow they've jerry-rigged the voting, the districts, so that them as the minority have the majority voting power over the majority of the people there who happen to be of color, black and whatever other ethnicities. So what I do like that she said about the race piece is, yes, the race is always present. There's always, consciousness of it, but it doesn't mean that everyone is just going to vote for somebody black, because you're going to have mixed folks inside of these larger areas. And it doesn't mean that they aren't going to be voting on the thing that's appropriate for the majority of the race. Is that, you guys get what I'm saying there? Does anybody understand what I'm saying?
Alexis, did you want to chime in? Welcome to the stage.
Absolutely.
Oh, I'm just listening to you guys and learning. Thank you.
Mm-hmm. Absolutely. Alexis,
okay.
Good to see you. Good to hear from you. But do you understand what I'm saying, Norella?
I understand what you're saying. That's what I'm saying. It goes back to the point of they've been voting for white representatives.
Right.
Because based on how they keep redistricting the lines, those who actually run for positions representation happen to be in districts where the representatives are white, and the majority of even black population still vote for white people. And so to her point, it's not about race. It's literally about, party discrimination. And that's what she said. Mm-hmm. And that is a true statement.
Mm-hmm. Well, I mean, and that's my whole point, is like, So while clear people are upset and say, oh, we got to protect, we got to cover our ass. It's not just, and that's I think why the question was loaded, the political question about voting for party is wouldn't that be considered the same as voting for race? When in fact, no, it wouldn't be. So anyway, that's just kind of like what I got out. But I'll keep. Let me hit play again.
Alexis, you had your hand up. Did you want to say something?
So sorry, that was a mistake.
Oh, okay.
All right.
All right, let's go.
If I may address the durational limit question, which came up, I'd like to talk about the fact that Section 2 is self-limiting. I know that there is a general concern about the indefinite use of race, and there are several reasons why that concern should be allayed. First and foremost, there is no precedent to suggest that a statute must dissolve on its own simply because it may require a race remedy. And as I've mentioned, race is not required by Section 2, but it can be used if that is necessary to address the Section 2 violation. In addition, the non-discrimination element of the 15th Amendment is a permanent right, and so should be the protection that Section 2 affords. And finally, this is a significant concern where Congress was very clear that it did not want to include a durational limit. Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So, for example, this case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act, and also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. That particular aspect, I'm guessing, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because, can I ask, I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
Just assuming
that it
my
does.
question is.
Sure. Assuming that it does, as you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting
so,
the
Ms. Nelson,
1982
I guess I
amendments.
wonder if it would be helpful, at least as I'm thinking about it, because I think this is a very important question. To understand, I think that you're saying that Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist, and those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to figure out what that remedy will be, and maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
So that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right. And its usage becomes less and less as we see racially polarized voting and residential segregation decreasing. The Katz amicus brief in this case shows that in the past decade, Section 2 cases have decreased by 50%.
Because the plaintiffs can't make the showing. I mean, it's a pretty significant showing to establish that unequal opportunity of electoral processes is happening in a situation.
That's correct. Jingles is an exacting test. It is data obsessive. It brings in experts and many other forms of evidence to establish a racial violation. There are many cases where the plaintiffs fail in bringing the Jingles 1 precondition or Jingles 2 or Jingles 3 before they even get to the totality of
So if we're talking about a
circumstances.
time limit, you would say maybe it's with respect to the remedy that is used to respond to the problem that we've identified under Section 2. But the Section 2 tape measure itself doesn't need a life cycle. It's just,
No.
yeah.
That's correct. I mean, the 15th Amendment is permanently enshrined in our Constitution, and Section 2 is there to effectuate that prohibition of race discrimination on voting and does not require a time limit.
Thank you.
Let me stop it right there. What are you guys' thoughts about this time limit question? Because I felt like that was pretty loaded from Kavanaugh. Like, maybe from.
He cut her off too.
Well, he did do that.
So did Barry, but they cut her off from getting to a point where she is actually, I think, in my opinion, trying to give them their ideas of how they're going to rule. So, you know, they didn't want her to finish or get to the premise of making the argument, and I mean, just sealing the the casket closed. Because of course, we're talking about this is documented, right? So, you know, all this is written down. It's going to go into records and archives and stuff, so it's documented. My thing is that the time limit question is kind of like premature. It's premature because they have to still rule on their decision. And I think shout out to Black Majority. He posted Jefferson County refusing to draw a fair map. But that's happening around the country, and it's been happening.
Right.
We get into the Democrat versus Republicans because of our reparative issues, right? But when we're actually talking about how voting is actually being manipulated by people who want to, again, keep control of state power, legislative, which is incumbents, the legislative branch and the judicial branch. we need to be on a serious. We need to be serious about this thing.
Right. Well,
and I think we've been behind the 8 ball because we weren't really educated on our political engagement. But
well, let me swing back over here to the time question that you interrupted me on, Rella.
I'm sorry.
It's okay. That's all right. You know you do.
I thought I answered. Did I at least answer?
Well, no, because I really was building just a little bit. Black, I see your hand up, and definitely please jump in. But I'm wondering what was his motivation for asking about a time, because if we're telling you that this, the governmental entities are creating these bodies and these policies that disenfranchise us. And if you come in as a Supreme Court and say, hey, you guys got to treat this group of people right, why would why should there be a time limit on it? Why would you need to put a time limit on it? Even if people naturally evolve into acting appropriately, why do you have to? You only need to do this for 5 years or 50 years or 100 years. Why is there such inquiry regarding a time limit on allowing there to be an equal playing field? That's my question. I'm wondering if anybody knows the answer. Black, your hands up. Go ahead, baby.
Yeah. I actually put my hand up just for that time limit. So again, shout out to her. I did put a few of her posts. Please follow her account here on X, the Legal Defense Fund. But and I've added her in the past about some things that I was concerned about. But at any rate, so the time. So she keeps saying, and this is why words are so important. She keeps saying it's a permanent part of the U.S. Constitution. It is permanent. Permanent. And the reason for that is these constitutional amendments are permanent parts of the U.S. Constitution unless they repeal it, right? That's Congress. Congress has the power to repeal amendments, and it's a huge hurdle, 2/3 votes, whatever it is. What this guy and the rest of these justices and the people who brought the case are trying to do is amend the Constitution. And that's why they're talking about these time limits, because they want to get rid of that provision. They want to get rid of it. So they want full disenfranchisement, period.
Right.
And so if that happens, and I mean, dear God, if that happens, it's unconstitutional if it happens. That's why she keeps telling them it's a permanent part of the Constitution. So I'll land with that.
You know what? I would love to get her in there's another attorney on the platform. She is a constitutional attorney. I would love to get both of them in a space and really, really dig deeper into the context of this hearing and the context around our responsibility with, law in the Constitution, and how we are supposed to also use that at the ballot box and not just vote for any old body. And this goes even to my question about representatives or people who run for office. Should they be, should they be required to have some form of state law education or knowledge, because it seems like something is missing in that area. And that might be a little bit too broad, but I'll go ahead, Alexis, you got it.
Thanks for the great space in this question. I did want to say that if the Congress had intended there to be a time limit, the Congress would have legislated it as such, because the Congress has that ability, that capability. Oftentimes you find the justices saying specifically, this is something that belongs to the Congress. And I think that's part of the problem, that we're in an environment now where the Congress is basically just given up their ability to legislate. They're letting themselves be run roughshod over, in my opinion. So I think that's a piece of the problem. They would have done so. And also to what God is Good was saying about the amendments of the Constitution. If you're constantly having to amend the document, which I understand you need to amend it for some things, right? But if you're constantly having to amend it, then there's something inherently wrong with the Constitution. This is why there haven't been like a ton of amendments, right? The document has to leave some room for interpretation, but it's very clear in it. But I just wanted to stick to the point that the Congress, had they wanted it to expire, they could have legislated it to be so. They've not done it. So if the Congress would like to do that, then they need to go legislate, and it needs to go through all the process for, amending the Constitution. As simple as that.
Yeah.
And to call themselves original constructionists, this is crazy.
Well, and that's what I wonder if that's where Brett Kavanaugh was trying to steer this thing. Like, is that your dog whistle? Like, hello, somebody, put a time limit on this thing. No matter what this fantastic, beautiful black NAACP representative lawyer is arguing so eloquently and efficiently, put a time limit on it so we can be done with these things. Who knows? If y'all ready, I'm going to hit play. Oh, go ahead, Black.
Yeah, I was just going to follow what Ms. Alexis said. So if they have to keep amending the Constitution, it's because the original writers of the Constitution were cowards.
Ooh.
All of their writing said that they were trying to establish a pathway for the enslaved to eventually gain citizenship, blah, 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 blah. A lot of lip service, right? But they were cowards at the end of the day, and that's why they have to keep rewriting and adding amendments to it in order to defend the population from these sociopathic, violent terrorists that exist in this country.
Yeah,
that's what it is. I'll land with that.
Yeah. All right. Let me hit play. Let's get right back to it.
At the time I have remaining, I'd like to mention that there are many proposals on the table that have been presented by my colleagues on the other side, and a number of them resurrect the intent standard that this court was very clear about, and Congress was extraordinarily clear about, knowing that results is key to ensuring that we do not continue to have rampant racial discrimination in voting. And the absence of it, or the declining ability to show a Section 2 case, is because of the success of Section 2 over the past 4 decades. And we would be reckless if we determine that Section 2 somehow is no longer needed simply because it has been so successful in rooting out racial discrimination in voting. There's also, as I mentioned at the outset, a very easy and elegant solution to this case. If SB 8 is not satisfactory, if the court believes, as the Callais panel did, that the state violated the Constitution in constructing SB 8, it should remand and use one of the many alternatives that are available that meet Section 2 and also comply with the Constitution. The liability finding in Robinson is undisturbed, and it must be remedied. If SB 8 is the inappropriate remedy, there are many other options for this court to pursue.
Thank you, Counsel. Justice Thomas, anything further? Justice Alito?
Yeah, let me pick up with where you left off, which related to the illustrative map in the Robinson case. And let me go back once again to what we said, what the court said in Milligan. The minority group, this is the first Gingell's precondition, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. Did the Robinson court apply that, or did the Robinson court simply say that the district in question in the illustrative map, the second majority minority district in the illustrative map, was compact? There's a big difference between the compactness of the minority group and the compactness of a district.
All of the 7 illustrative maps that we presented to the Robinson court were geographically compact. They met every traditional redistricting criteria. They even beat the state's maps on the very criteria that the state set forth that it was pursuing in the redistricting process.
Well, that wasn't my question. My question was, did the Robinson court find that the minority group was compact as opposed to the district being compact?
Yes,
it's a very
did.
serious.
Yes, it did.
I believe it didn't, and nor did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious question about whether the black population within the district in question in the illustrative map was geographically compact. You have people from a rural.
Okay, wait. Say, what's your point again?
Why would he bring up the Fifth Circuit when it went to the Supreme Court and the Supreme Court ruled over the Fifth Circuit?
And probably while he was sitting on the Supreme Court.
Right.
Dummy.
So how is that, like, to me, how is that his rebuttal that, well, the Fifth Circuit ruled X, Y, and Z? Yeah, but it had to come to you to override what they had ruled in the first place.
And it's possible maybe he dissented from it. And since I got both screens up and my phone in use, I can't look it up. But I'd like to know if he dissented from that.
Let me look it up while you do
that.
And
I posted it back just a little. I'm sorry.
Yeah, I was about to say, can you just replay that section? Okay.
Absolutely. Here we go.
Area in the northwest part of the state, and you have people from an urban area many miles away combined in a district just for the purpose of getting over the 50% BVAP.
So, Justice Alito, you might be referring to SB 8 as opposed to the illustrative map.
No, I'm referring to the illustrative map, although the same may be said about SB 8. But I'm referring to the illustrative map. Well, we don't need to argue about what was done in the case, but it's my firm recollection.
Six maps joined people in districts from the far north all the way down and across the state.
That's correct.
The map that it put into effect.
Did we lose?
So the district wasn't compact, and neither were the interests necessarily compact, except that they were white voters, correct, and Republican.
Correct.
All right. Now, you have not addressed...
Wait, who did you lose? Who did?
Let me see.
Did you lose me? Can you hear me, Rollo?
Shoot.
Uh-oh.
Hold on, let me text her.
Okay, she must can't hear me, you guys. So YouTube. Like my man, I forgot what the content creator's name is. Yeah. So yeah, YouTube. So, we're trying to do the with the Twitter gang. You guys hit the like button, share, subscribe if you haven't already. Get in here and leave a comment for me too. Who's in the bushes? Who is that? What you doing? So we're on Twitter. We're listening. Just the old gang. We're on here breaking down this Supreme Court oral argument and the redistricting issue going on in Louisiana. We have this fabulous. I mean, man, this black woman is fantastic, and these are the type of women that we need to be having front and center in terms of role models and mentors and leaders. Hold on, we got Rel on here. So hold on just a minute here. Okay. Yeah. So Rella's on deck too. She's talking to the Twitter sphere. Let's see.
Guys, thank you so much for hanging out with us. Of course, the freaky diggy professor in the building, and of course, Miss Alexis is in the building. Thank you so much, you guys, for being here.
And certainly can't forget. Certainly we can't. Cruz, you already know. So yeah, so I was just kind of catching up the YouTube audience, just on where we are, and I don't know what happened. Looked like there must have been a disconnection.
Yeah, because we couldn't hear anything.
Yeah.
Alexis did have a question of what was being said, so I know you're gonna roll it back.
Yeah, absolutely. So, but now, Alexis, do you want to share your question and shout out to everybody in the space? We're also live on YouTube. Don't email Cruz. If you want to pull up and jump on the panel over on here, you feel free to do so. We're doing it all together tonight. Gang. The gang's all here. Did you have a question, though, Alexis?
Yeah, it was just a question based on what you would ask. You asked, did Thomas dissent to something?
Yeah.
And I was wondering if you were asking, did he dissent in the Milligan case?
Yes, that's what I was trying.
He did dissent.
So now that's interesting then, because why are you using this time and space, Alito? Because that's who she was arguing with, right? Wasn't that Alito at the time? why are you using this time and space to re-argue something that has already passed, apparently the Milligan case, they were successful in it. So why are you using that to, again, show your disdain? This is why Kavanaugh was asking about the time limit, because from my perspective, you know, okay, I'll be fair if I only have to do it for 5 minutes. You know what I mean? That's what it's giving from my perspective. Let me see. I don't know where this cut off for y'all, so let's see.
Did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious...
Well, Alexis did just answer it, that he did dissent in the Milligan case. Yeah. So he did, and that's why I was wondering, like, he didn't agree with what it was. That's why he's arguing it. So let's get back into it real quick.
Question about whether the black population within the district in question in the illustrative map was geographically compact. You have people from a rural area in the northwest part of the state, and you have people from an urban area many miles away, combined in a district just for the purpose of getting over the 50% BVAP.
So, Justice Alito, you might be referring to SB 8 as opposed to the illustrative map.
No, I'm referring to the illustrative map, although the same may be said about SB 8. But I'm referring to the illustrative map. Well, we don't need to argue about what was done in the case, but it's my firm recollection that what the district court did and what the Fifth Circuit did on appeal was not to apply the correct standard under Milligan. Thank you.
Justice Sotomayor?
Counsel, I would note that the state's maps joined people in districts from the far north all the way down and across the state.
That's correct.
The map that it put into effect. So the district wasn't compact, and neither were the interests necessarily compact, except that they were white voters, correct, and Republican.
Correct.
All right. Now, you have not addressed the issues of the unconstitutionality, which is what this re-argument was about. Justice Barrett mentioned congruence and proportionality. Others have suggested that our Harvard case is appropriate. One, Louisiana has said that the use of race in any way violates the Equal Protection Clause. Would you give us a couple of lines on why those, assuming, as the Chief did, that Mulligan and all of our cases and precedents support you?
Sure.
The others are now saying, your adversaries are saying, even if it does, we should still declare this unconstitutional. I don't know that you've addressed that.
Happy to. So SFFA is an entirely different case from the one before the court at the moment. SFFA made clear that it is still constitutional to use race to remedy specified discrimination, which is what we have in the state of Louisiana, what we showed before the Robinson court. So SFFA is, in fact, working more in our favor, we believe, than supporting our opponents. And there are many distinctions between this case and the SFFA case. For example, Section 2 is a decidedly remedial statute. SFFA involved the diversity rationale involving a admissions process with a university, not a statute that is derived from Congress's enforcement powers under the Reconstruction Amendments that deals with remedying discrimination. That is a very clear distinction. This court has been clear in Shaw, in SFFA, in Croson, in Fulilove, that you can use race in a limited way to remedy racial discrimination. The other factor that makes SFFA reconcilable with Milligan, which is controlling here, is that we know both decisions were issued within 3 weeks of one another. It is illogical to think that this court issued the SFFA decision and Milligan in the same term and the same month even, and somehow those cases work at cross purposes with one another. So in our view, it is very clear that the case law before this court supports the use of race as needed once there has been a showing of specified discrimination. And the Section 2 test gives the court an inference of intentional discrimination to draw upon. Congress was very intentional in crafting the results test to balance the concerns of getting at all discrimination in our electoral processes, but also being mindful of a potential allegation of racism against states and other state actors. And so Section 2 requires neither a confession nor an accusation of racism. It looks strictly at results, which this court has upheld on numerous occasions, including most recently in Milligan, but before that in Lopez, in Bernie, in City of Rome, written by Justice Marshall for this court, made very clear that results is constitutional and that the use of race is permissible in remedying discrimination.
Justice Kagan?
Ms. Nelson, were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is black was elected from a VRA opportunity district. We only have the diversity that we see across the South, for example, because of litigation that forced the creation of opportunity districts under the Voting Rights Act. Every justice in Louisiana has been elected through a VRA opportunity district, and nearly all legislative representatives have been elected on those same districts. So Louisiana alone is an example of how important it is to have Section 2 continue to be enforced to create these opportunities. We also know that after majority-minority districts have been created, they often no longer need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process, but it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
Thank you.
Justice Gorsuch?
Okay, so yet again, Twitter, currently known as X, is clowning, has kicked me out of the situation again. Shout out to Elon Musk for always jacking up the situation. Hold on just a minute. We're trying to get right back in there. Rella's texting me on the bat line, trying to get back in. This is a damn shame. Well, I tell you, Twitter acts like a Tesla. Okay? Let's see. Let's see. Black in here giving some information. Hold on just a minute, y'all.
They should be able to do number 6. I mean, that just doesn't. The arguments that they're making.
So can you say that in layman's terms? So I'm looking at the map, and I see number 4 is in red. So for those who are down in the audience, in the jumbotron, there's a map. The red represents the GOP. The blue, I'm assuming, right, represents the Democratic Party for both 2020.
Yeah, shows.
Am I looking at the first? Oh, okay. I'm looking at the first. Okay. Yeah.
Look at the second one. So it says District 1 is 68% Republican.
Yes, I see that.
And then you see over, if you go to 2022, 71%. So all these ones in red in this little key box are the Republican districts, which is 1, 2, 3, 4, 1, 2, 3, 4.
You see something, y'all?
And so before this, and you'd have to find the map, before this 6th district apparently didn't exist. And so they had to create it so that you get a second black seat because there was only the one.
Okay.
Only one existed. And so they had to create this. And so what they're doing is saying, so if you see District 2, that plus the black majority district, which is probably, I don't know, New Orleans or Baton Rouge or whatever it is down there, right?
Right.
And so it kind of makes sense that the population of Black Americans would connect to that district. That's just logical. There's probably a highway or some system that connects that. So they just kind of extended that out in the direction of where And even with that, it's still only 59%. They still got 40% on the other side. So they didn't even make it like a super black majority district. They still gave them a fighting chance. So this is weird, man. At the end of the day, it's just weird.
So they essentially want to take that. So the people who are bringing this up, suing, is saying, hey, we don't want to give any more majority district opportunities to the majority black people. We need to keep this essentially all non-black power. Essentially that's what's happening. Am I wrong, or ding ding ding? That's what they're trying to do with all this stuff. So, there she goes. Only Mel Cruz is back. Okay, let me give her back the co-host.
Yeah, we're back in here.
That picture.
Yeah.
Was there another one up here? Oh.
Let's see.
Okay, so this is what I was gonna say. So, because Twitter keeps acting up, we can go over to the Only Mel Cruz YouTube channel if you guys are okay with that, because I feel like there will be less interruptions and cutting off. Like, this is, I really want us to really, go through this. So if you all, the link is in the Jumbotron.
That it is. No, I said that it is. I just put it in there.
Yes, ma'am. And I'm going to go ahead and close this down. So for those who are going to travel over with us, please come on over. If there's a way for you, you have it. So we can come up and talk. And
yeah.
We will be on our way.
Yeah.
I'm going to give my outro. If anybody want to give some last words before we leave out of here, let's do it. And I'll give my ending outro for this episode.
Yeah. I'll tell you, great space, awesome space. I'm glad we had the opportunity to get here, and hopefully we can, who we have in the audience now, you guys can pull over to the YouTube so we can finish chopping this up. I'm glad that we've been able to get together as a group and dive into this, because it's been extremely informative in my view. So thanks for doing this, Rella.
Thank you so much for being here. We are going to convene and join over to the Only Mel Cruz. We on Your Head podcast. Be sure to follow, like, subscribe, all those things here if you care, if you love, and you are for the evolution of Black majority states and Black Americans. Please join us over there.
Yeah.
And remember, top of the hour will be coming on more often with Relevant. So there is a YouTube channel being constructed for Relevant, and we will be having top of the hour topics. Again, this is your girl, Sister Rella. I have, of course, God is good, because all the time God is good.
Ain't he though? Won't he do it?
Of course, we have the Mel Cruz in the building with special guests, of course, Miss Alexis, Professor, and we had Brother Detroit up in here. What up, Joe?
Shit.
And shout out to the listener section. We appreciate you all for being here. And remember, if you don't do anything at all, remember that active action is more fruitful than passionate action. Please remember that. Okay, it's good to have passion, but remember, you need to put it into action. All right, you all. This has been another top of the hour, and I am your girl, Rella. Peace.
All right. And so for those of you that are in the YouTube streets, don't leave, because we're still live and in full effect. And hopefully some of the gang will be able to come over here to the YouTube channel so we can finish chopping up this. I mean, this is, oh man, we're not even behind the scenes, because this is public information, but sometimes it's hard to understand all that. And so it's great when you have a group of intellects that you can get together and say, now, wait a minute, what? Huh? Somebody break that down, or somebody pull that up on Google, and now what's going on? So, and that's what we're doing here on the Supreme Court oral argument. Janiyah Nelson is fascinating, you guys. I'm just so impressed. Um, I'm just going to read a little more information about her while we wait to see who from Twitter is going to migrate over here. Um, let's see. It says here that Nelson was one of the lead counsel in the Veazey versus Abbott 2018, a successful federal challenge to Texas's voter ID law, and the lead architect of the Null versus Trump 2020, which sought to declare the Trump administration's executive order banning diversity, equity, and inclusion training in the workplace unconstitutional before that was later rescinded. So prior to joining the Legal Defense Fund in June 2014, Nelson was an associate dean for the faculty scholarship and associate director of the Ronald H. Brown Center for Civil Rights and Economic Development at St. John's University School of Law, where she was also a full professor of law and served on the school's senior leadership team. You guys, come on, we got history working. This is Black History live and in living color. There's just no doubt about it. Shout out to Black State of America. Black, I'm happy to send you the link if you want to come up. You know how we do it, cam down, cam on, however you want to get down. Happy to have you on here, but I'm glad you pulled up because listen, just tell me, yeah, if you want me to send you, drop the link for you. Same for you, Rella. Matter of fact, let me do this. Let me make it easier. Let me just drop the link. And then y'all can pull up on here and you can do that with, like I said, cam on, cam down, no matter to me. Just get here. How about that there? So the link is in the chat. Pull on up if you like. But let me get, this is Walking Black History. And so Black, this is another one of those, this is one of those community conversations that we're going to have to get started in terms of Black History Month, and this is another unknown or unsung hero, if you will. Let me finish reading here. Just so interesting. So she also associate dean for faculty scholarship and associate director of the Ronald H. Brown Center for Civil Rights and Economic Development at St. John's University School of Law, where she was also full professor of law, served on the law school's senior leadership team. A renowned scholar of voting rights and election law, Nelson continues to produce cutting-edge scholarship on domestic and comparative election law, race, and democratic theory. Nelson's publication, Parsing Partisanship, An Approach to Partisan Gerrymandering and Race. This appeared in the New York University Law Review, October 2021, and proposes an option for the Supreme Court to address hybrid racial and partisan gerrymandering claims, despite its findings that partisan gerrymandering is non-justable. I'm not even pronouncing that correctly. Non-justiciable. I got to look that word up, y'all, because she got me there. Let me see. She also published Counting Change, Ensuring an Inclusive Census for Communities of Color, which advances a theory of representational equality in which all U.S. residents are to be counted and served as constituents, and that centers the census and accurate count of the county's most vulnerable populations in the functioning of our democracy. Man, this lady is fascinating, you guys. Let's see. Rella said, I'm here. Rella said, fact, she's sharp. Okay, so I put the link out. You guys didn't pull up, but let me keep running this video, and let's just hear more about this fantastic lady. Let me see. Let me switch up something real quick, too. Hold on just a minute. Since not on, break it down, break it down. Okay, here we go.
When it gets to the remedy side, do you think a plaintiff in a Section 2 case has to come up with a map where
you guys can hear okay? Is that right? Can you put something in the chat? Let me know you can hear.
In the map, or is it okay for a federal court to use a map on the remedial side that intentionally discriminates on the basis of race?
You do not have to use race to create the remedy in a map, and I think that
No, I'm asking whether one can. Sometimes you don't have to.
Yes.
I understand that. I'm asking, is it acceptable under Section 2, as you understand it, given our precedents, for a court to intentionally discriminate in a remedial map on the basis of race?
Not in those words, not for a court to intentionally discriminate, but I think it depends. There may be a circumstance where the only possible remedy is the limited use of race. I will say that I think those circumstances are rare, and the permissibility of race is constrained by strict scrutiny. This court has a very clear precedent around ensuring that race does not motivate the line drawer in a way that requires a map to be drawn that isn't narrowly tailored, that uses race for race's sake. There are already constraints between Jingles and Shaw that keep the use of race within constitutional bounds.
I understand that, but one argument is often, well, once you've found a Section 2 violation, you've got a compelling interest to go ahead and discriminate on the basis of race in your remedial map. And I'm just wondering, do you endorse that view or do you reject that view?
I don't endorse the concept of discriminating on the basis of race if discrimination has been established under Section 2 and a state determines that it needs a very precise incision of race in order to remedy that Section 2 violation, then Section 2 and this court's precedent supports that.
So a federal district court can sometimes to remedy a Section 2 violation.
Well, not a federal district court. I'm sorry. I'm glad you emphasized that.
If I might just finish the question.
Yes.
Sometimes federal district courts order maps, and you're saying sometimes acceptable for a federal district court to order a map that intentionally discriminates on the basis of race.
I disagree with that formulation. So first and foremost, states and plaintiffs, as they put forth illustrative maps, cannot put forth maps that discriminate and that use race in an excessive fashion. The only actor that has broader leeway are states, because we give states breathing room. We give states wide latitude in order to balance their political interests and concerns.
So federal district courts can't discriminate on the basis of race in remedies, but states can?
Federal district courts can only order maps that are constitutional. And again, the constitutional boundaries are between Jingles and Shaw, which sometimes permits
states
race.
have more breathing room. So do they have the breathing room to intentionally discriminate on the basis of race?
They don't have breathing room to intentionally discriminate on the basis of race. They have breathing room to use race to remedy their own discrimination.
Okay, thank you.
Justice Kavanaugh?
Just the hang up there was
I kind of want to jump in here real quick and shout out to Sister Rella, who is live and in living color on deck. We holding it down on the Mel Cruz show with ATP at the top of the hour. And we just kind of collaborating. It's a collab on that end. And we're talking about the Supreme Court oral argument. And this is fascinating, phenomenal. And, now listen, Rella, can you hear me?
I can, loud and clear. Can you hear me?
Absolutely. You know what?
Okay, perfect.
So, here's what's interesting. Because let's be honest, I hear a little sassiness as we're is a term we're using now these days. But I'm hearing sassiness from some of these justices in speaking with Janaya, or I don't know what the correct pronunciation is of her name, but in looking at what this woman, the scholarship this woman has authored, I see why. And this woman is a walking intimidation signal. I think some of these folks are intimidated by her because she knows more about the topic. She's the subject matter expert before they are. And I just want to revisit very quickly, because I was reading this as we were making the transition from your awesome space, highly informative, highly educational. Nelson is a renowned scholar of voting rights and election law. This lady's been on the senior leadership team of the NYU, or as you were, St. John's University Law School. She was also a full professor of law. She served on their senior leadership team. She's written books for NYU, or some articles. She's a published author. Parsing Partisanship, an approach to partisan gerrymandering and race. She is perfect to be having this legal discussion and contributing to what these this Supreme Court needs to consider in determining exactly which way they're going to vote. I mean, this lady is phenomenal, and so this is where that sassiness is coming in at. That's my view anyway. And shout out to Sir Miguel. Thank you for sticking around, boy. I sure appreciate you, Sir Miguel. You said some of the justices appear to not want to hear the argument. Absolutely, I agree with you. They're like, psh, you know, it's like it's just a performance, and they're doing it because they have to. It's interesting because for some reason they seem to be giving time for it. And so then that in and of itself is a question. But anyway, let's get back to it. Looks like Rella dropped off. Let's get back to this good thing. Here we go.
The word discriminate, but your answer is that they can intentionally use race in those circumstances, correct? The federal district court.
If needed, and there are often a wide range of possibilities and alternatives that don't require that.
And then I think you said so long as it's not excessive, and you mentioned strict scrutiny as well, correct?
Correct.
But part of strict scrutiny, again, is the temporal limit. That's been part of strict scrutiny for a long time. And I think your answers earlier to that, to me, and when you were talking with Justice Jackson, were, well, Congress, defer to Congress. But when we're applying the Equal Protection Clause, or as Justice Barrett said, the 15th Amendment, congruent and proportionality, or 14th Amendment, deferring to Congress is, I think, not what we're supposed to do. So what, if we're not just deferring to Congress, is there anything you can point us to that would not allow it to extend forever? The intentional use of race, which you acknowledge in response to Justice Gorsuch.
Sure. Well, we maintain that there does not need to be a durational limit, but there is some guidance that this court could consider. So, for example, in Grutter, the court, Justice O'Connor, suggested that affirmative action did not need to endure beyond another 25 years. She forecast that another generation might need affirmative action, and ultimately this court thought otherwise in SFFA. So that sort of runway, that advance notice, that expression of an ability for Congress to intervene if it disagrees with the court or decides it wants to remedy on its own, that is the type of guidance I think this court should consider if it feels that it must pursue a durational limit on Section 2. And again, we don't believe that's necessary.
Do you, Justice Kennedy, in 1994 in Johnson versus DeGrand, he said a couple things I just want to get your reaction to. He said the sorting of persons with an intent to divide by reason of race raises the most serious constitutional questions. And he added that explicit race-based districting embarks us on a most dangerous course. It is necessary to bear in mind that redistricting must comply with the overriding demands of the Equal Protection Clause. Do you take issue with what he said there?
No, what I think is missing from the understanding of Section 2 is the work that it has done to advance the goal of ridding our electoral process of race. It brings racial groups together, and as I mentioned earlier, many of the VRA opportunity districts ultimately convert to non-majority minority districts. Not all VRA opportunity districts are majority minority districts. And in fact, we see greater racial harmony and less racially polarized voting as a result of Section 2 districts. So Section 2 is addressing a pre-existing problem. It is not producing it. And in fact, it reduces it more broadly across society.
Thank you.
Justice Barrett?
So we've assumed, without deciding, this is picking up on Justice Gorsuch's questions, that complying with Section 2 is a compelling interest for purposes of the 14th Amendment.
Correct.
And now this is kind of picking up on some of Justice Alito and Justice Thomas's questions earlier. How are we to think about that when we're thinking about the Robinson litigation? Because it was a preliminary injunction, and Louisiana, of course, argued there that no, it wasn't a violation of Section 2 to have those maps. So I guess, how do we judge the compelling interest in avoiding a violation of Section 2 if the state doesn't really think it violates Section 2 and it hasn't been finally adjudicated yet? How do we approach assuming that compliance with Section 2 is a compelling interest? How do we think about that in a context like Robinson?
So states can, for good reason, draw a map that addresses Section 2 prophylactically. Here we have a finding from a district court based on a robust evidentiary record that we were likely to succeed on our Section 2 claim. This is not the first case. There are many cases that have provided the basis for an opportunity map to be drawn just on a preliminary injunction motion. And again, that finding by the lower court was affirmed by 2 federal panels of the Fifth Circuit, and this court had an opportunity to revisit the Robinson litigation and did not.
But what if, I mean, district courts sometimes make errors of law, right? So what if the district court, I guess I'm trying to figure out how much weight then the district court's finding has in comprising that compelling interest in avoiding the Section 2 violation. Do you see what I mean? Like, what if the district court was just wrong, and what if the state thinks that the district court was wrong?
Well, the state has already conceded that it.
Okay, no.
The state already conceded that it should comply with the Robinson decision.
Right. I mean, it got complicated here because of all of the other litigation, but why don't you just strip out what happened and answer the question, like, at the time Robinson was decided, if Louisiana thought that the Robinson court was wrong, that the district court was wrong, but it wanted to avoid the court-imposed map, wanted the opportunity to draw its own map. Justice Kavanaugh's been asking you what role race can play without running afoul of the Equal Protection Clause. And the state would have to say at that point, well, we're weighting race heavily because we have a compelling interest in avoiding a Section 2 violation. And the state's position might be, we don't actually really think that we violated Section 2, but we have a litigation risk. We know that if we don't draw this other map, the court may impose one. On that understanding, on those facts, not concessions and whatever is made, is that then a legitimate, compelling state interest when there is the possibility and the state in fact thinks that the district court was wrong?
It is still a compelling governmental interest. The state can do what it did here, which is to appeal to the Fifth Circuit, and the Fifth Circuit considered the same evidence and unanimously found that the Robinson court was correct. Yet another Fifth Circuit panel also affirmed that decision.
Justice Jackson?
So in essence, are you saying in response to Justice Barrett that it's a compelling interest nonetheless because the state has an obligation under our Constitution and under Section 2 to provide an equally open electoral process?
That's correct.
I mean, I guess what I'm trying to really wrap my mind around is the different stages of this case and like the different questions at issue, because it's complicated. But I think the beginning of the whole thing is the requirement of equal protection in the Constitution and Congress's determination under Section 2 to make sure that that is being provided to minority groups in the electoral process by having a statute that requires states to provide equally open electoral processes. I mean, that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody, I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson court is asked under Section 2, is this a situation in which that's not happening? And they go to trial and they bring in a lot of evidence and they do the thing, and the Robinson court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson court's decision is before us right now, because what I understood is that as a result of the Robinson court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson court has identified, and we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson court's initial identification of the problem is being questioned as
So,
of
so I
compelling
have a
interest,
question.
because there's an interest in not
Yeah,
having.
yeah, I
So
do too.
I have a question.
Yeah.
So are they, oh, so, okay. So they brought the case to the Supreme Court because white people want to be able to say that it's discrimination because they're white.
Mhm.
Is that what I'm hearing?
No, no, the case is being seen because they apparently, in my understanding, they had to bring the state of Louisiana to court because they drew a map, they gerrymandered a map that disenfranchised black folks. So
No. So the people
wait, wait, wait,
who,
wait, wait, wait. I'm trying to catch up to where you. But go ahead, Bella. Go
no,
ahead.
I'm saying, so the people who brought the case are non-black, right?
Well, this
And
wait a
that,
minute. Go ahead. Go
so
ahead.
I'm saying, so that's why Ketanji is asking in that way. Now, Amy Coney Barrett was, she was a little raggedy with her.
Well, I think they're all confused at this point. And again, my understanding is they jerry rigged this map. And so the
Yes, they
case,
did.
okay, hold on, let me walk, and then you can, because you see what I'm saying.
Yeah, yeah.
They created the map, and the people say, "Hey, this ain't right. You
Mm,
got us all jacked up in the game." So
mm-hmm.
so they took it to the court. Court said, "Hey, this is jacked up. We need you to write another one." And they said, "Since you guys want to keep the map you drew, that's fine, but you're going to have to create another map to ensure that black people get fair representation as a result of their voting." And but so it was so I'm not clear uh if they went back to the drawing board or if the map, maybe it was Milligan, but the map was drawn for them. But they, to my knowledge, how I understand it, they don't want to exercise and utilize this map. So this is why it is now back again in front of the
In
Supreme
front of
Court,
Supreme.
because they don't
Okay.
want to use it. We got the two versions of the map,
Mm-hmm.
the discriminatory one, and then the one that would solve it. But now the ones who created the discriminatory map don't want to use it.
Right, because again, it would go against why, and from my opinion on hearing what Katanja is saying, why is this in front of us when they already know they have the resolution to solve their issue, but they're bringing it in front of us to say, hey, yeah, well, now we need the Supreme Court to go ahead and allow us to use race now because it's relevant for us to use race now. And it seems like the only person who understands what's happening is the daggone
Yeah.
Nicole. Gosh, what is her name? What's
Janaya
her name?
Nelson.
Janaya, Miss
Hmm.
Nelson.
Hmm.
She seems like the only one that really understands and can articulate it in a way where you get where she's coming from, and it also points out the Supreme Court justices weak areas in articulating and articulating themselves and ruling over cases. And I think they see that as a challenge too,
Hmm.
because Sotomayor was talking and I'm like, what are you talking about?
But I think their challenge that they're having here is, they know that they have whatever they come up with is going to set precedent. And then they also, when they say, we're not going to decide this, we're going to send it back to you guys and you guys work it out. And then they don't want to work it out, and then they come back, it's re-presented to them with an argument about, well, we thought you said, because this is where we're at now, you said we can't use race to make these decisions.
Yeah,
And
but
so
but you're not. But Janai is saying in certain instances you can, and it has been proven in a lot of cases that the Supreme Court has ruled over that you could use race in certain instances. And so now, are the non-black folks saying they want to use race?
well, it's not that plain, it's not that cut and dry, because and I'm going to try to get it where we'll put these captions on here real quick and see. So and if you're out there in the YouTube street, shout out, please hit the like button, subscribe if you haven't already. And we're just really trying to break this down. So in the other map, the court may impose one. Facts, it's still a compelling governmental interest. Let's get here and see what she's talking about right here. Hold on.
Robinson Court was correct. Yet another Fifth Circuit panel also affirmed that decision.
Justice Jackson?
So in essence, are you saying in response to Justice Barrett that it's a compelling interest nonetheless because the state has an obligation under our Constitution and under Section 2 to provide an equally open electoral process?
That's correct.
I mean, I guess what I'm trying to really wrap my mind around is the different stages of this case and like the different questions at issue, because it's complicated. But I think the beginning of the whole thing is the requirement of equal protection in the Constitution and Congress's determination under Section 2 to make sure that that is being provided to minority groups in the electoral process by having a statute that requires states to provide equally open electoral processes. I mean, that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody.
So like she just said, cancels out their voting strength. It's not equal. And if this weren't a racial thing, it would be a class thing. If they, let's say there were no more black folks in the, you know, like they want to do away with everybody and do away with anybody that has melanin in them, this same, because it's this moral decline.
Your mic is distorted.
Uh-oh. Can you hear me better now? Oh, my goodness. How's this? Any better? How's that?
You sound like a robot.
Uh-oh. Oh, Lord have mercy. We're about to wrap this up. Is this any better at all?
No.
Oh, wow. In the Matrix. Oh, Lord. Let's see.
How do you fix that?
I'm not even on the same. How's that? Is it better now?
No.
Okay.
It was getting too good. It was getting too good.
Yeah, evidently. So went out and came back in. How's this?
No, there's still some distortion. I don't know if in the comments they hear it. If they don't hear it in the comments, then we good.
Okay. Let me try something here. Let me do something different. Let me try this. Mike. Any better?
No.
Any better?
Same.
Okay. Well, oh wait, let's see. Is this any better?
Oh yeah, clear.
All right, great. So what I was getting at is if let's say they got rid of everyone that has melanin, they got rid of everybody out of this country. All you're going to have left is a class situation. Then you're going to have the rich and the poor, and so then they're going to, and if they choose to feign as though this is Constitution and rights and we serve you and Bosley Scoops and we're actually going to let you guys vote, which that's going to be some bullshit. Then what they would be doing is jerry-rigging and gerrymandering, where the poor white trailer park folks would not have a voice, wouldn't be able to vote, etc. So the whole point of this is that, from my very general interpretation, is because we have this issue and it's specific to race, we have to make a room and actually allow consideration of race, because that's where a piece of the argument is coming from. Because if there were no melanated people in here, then they'd say, well, we don't see socioeconomic status. And then they'd say, well, I thought we're not basing decisions off of socioeconomic statuses. But in fact, we are, because you guys keep making these maps that the man, the middle man out, or cut the melanated man out,
And
so
they focus on race. That was
right. So you did the harm
point
from a racial perspective, and now people come and say, hey, we're looking to be cured and made whole, and it starts with race because y'all started this fight. Now all of a sudden you're saying, oh, we'll see, no, we don't, we don't
We
see
don't
race.
use race,
Yeah,
right? Lies.
right.
But that was her
Yeah.
point, and that's why she said when she was talking to, was it Kavanaugh or Clarence Thompson? No, was it
It
Alito?
will be
One of them.
Alito or
One.
yeah.
It was, yeah. And she was saying that but we do have party discrimination, because they were like, well, we already ruled on race. Yeah, okay, cool. You ruled on race, but you decided to actually now start identifying people based on the party affiliations and assuming that party affiliation, to Black Majority's point when he asked the question, we know the affiliation of Black people in the Democratic Party, or the population number, right? But he said, well, what's the population number in the Republican Party for their representation, and who are they? I mean, he didn't say it like that. He might have said it a little bit more concise, but I'm saying it's on point, because no one brings that up in context, right? Which is why, having the top of the hour, everything is relevant in context, because if you understand that they're using they're akinning party politics to race, while saying we can't use race, but then asking the Supreme Court when it's a benefit to them to want to use race.
Well, I would say
That's
that
a
apparently
problem.
there are some laws that do have race in it. I guess if the Supreme Court could get by with it, they would. But let's just keep rolling, because I think we're caught in the middle of something, and the answer is way larger than we can compartmentalize it, at least at this point. But let's keep rolling with it. Hold on.
I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson Court is asked under Section 2, is this a situation in which that's not happening? And they go to trial, and they bring in a lot of evidence, and they do the thing, and the Robinson Court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson Court's decision is before us right now. Because what I understood is that as a result of the Robinson Court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson Court has identified, and we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson Court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court. There's no record in the Callais case to support that.
Thank you.
Thank you, counsel. Mr. Aguinaga.
Thank you, Mr. Chief Justice, and may it please the court. Race-based redistricting is fundamentally contrary to our Constitution. It requires striking enough members of the majority race
This guy.
to sufficiently diminish their voting strength, and it requires drawing in enough members of a minority race to sufficiently augment their voting strength. Embedded within these express targets are racial stereotypes that this court has long criticized. They assume, for example, that a black voter, simply because he is black, must think like other black voters, share the same interests, and prefer the same political candidates. And this stereotyping system has no logical endpoint. We are 40 years removed from jingles, and yet, according to my friends on the other side, nothing has changed in the voting and housing patterns in Louisiana that require race-based redistricting. These problems are part of why we never wanted to be here in the first place. They have placed states in impossible situations where the only sure demand is more racial discrimination for more decades. But I think if anything is clear in this court's dedication to eliminating all racial discrimination, it is that the Constitution does not tolerate this system of government-mandated.
Okay, so I gotta jump in. I took everything off the screen so that we could see the Scion coming off of C-SPAN. The Supreme Court heard arguments in March 2025, but ordered to hear the case again with the 14th and 15th Amendments in mind. Let's see here. But ordered to hear the case again with the 14th and 15th Amendments in mind. It's so interesting how we keep getting the pleasure, okay, of having non-Black individuals arguing so significantly about race and why it's,
Mm-hmm.
you see what I'm saying? We
Yes, he's not
and,
even a Black American talking about, oh, but there's different types of Black American identity in politics, and we shouldn't have to be hearing about race being utilized in when it comes to legal law or the major. What the hell? What?
and
Why?
here's the thing, and here's the thing, even with Nelson as the attorney arguing this case, we and then you have Ketanji Brown on there, and this is there's really not a voice for Black people because all she can do is argue the law. That's the only reason why she's there. And
Yeah, but that's what we're supposed to be doing, right?
No. Yes, absolutely. But my point, where I'm going with this, Rella, is that this guy gets to come in, and now he gets to argue. He gets to be the voice of the racists. He gets to be the voice of the people who are like, hey, that's not fair. This is here but order the Supreme Court. Hold on, I got to squeeze this back some. Let me see. Yeah, hold on. The Supreme Court heard arguments. Oh, shit, here we go. Heard arguments. Louisiana drew a congressional map that had only one majority Black district. A lawsuit followed based on the Voting Rights Act. This is me reading the scion down here. Let me take these things off of here again so we can see it clear. Because I'm going somewhere with my point here. And give me just a second so we can do it based on what we have on the screen. So Louisiana drew a congressional map that had only one majority Black district. A lawsuit followed based on the Voting Rights Act. Louisiana then added a second majority Black district, but non-Black voters sued on the grounds of illegal racial gerrymandering. And this is where Benjamin is coming in to argue on behalf of the non-Black voters. So these voters can get in here and just make all the claims and, hey, this isn't right. And, and their voice is able to be thoroughly articulated. Nelson, as articulate and knowledgeable and skillful as she is, and thank God for that, can only speak within very contrived guidelines, because she's only arguing the law. She's not arguing her complaint. And even Ketanji Brown, being Black and appearing to be the person the Black person on the Supreme Court who hey, yeah, I'm with you, I'm right for you, but I don't really feel that. She's got to phrase her questions and things very carefully. And your boy was Anita. What was that girl's name? Anita. The girl with the city.
Amy Coney Barrett.
No, I'm talking about Anita, the girl who tried to stand in the way of Clarence Thomas when they first got him.
Oh gosh,
that one Anita
not
Baker.
Anita Baker. Lord, not Anita Baker. Not Anita Baker. Not Anita Baker. Girl, that's a singer. Anita Hill, girl. Anita Hill.
Thank you. So my point. So we ain't got to worry about Clarence Thomas because he on Anita Hill time. You understand what I'm saying? So so everybody can speak freely and get theirs off, except for.
So this is, what this reminds me of? This reminds me of what happened with the Black farmers. And yes, and the reason why I bring that up is because the Latinos came in along with white folks, and they made the claim that it was discriminatory for Black farmers to receive aid. And when I say Black farmers, I'm going to say Black American farmers.
Right.
Black American descendant farmers, people who own land, who also are Americans, and under the Constitution, state's Constitution, they were within their right to receive aid from their, in their sovereignty and consent, from their government, federally and statewide. And immigrants who have children over here, which is why birthright citizenship is being challenged, are now getting into positions of authority, right? He's a solicitor general, solicitor, Louisiana solicitor general. And so he's arguing not on the behalf of all Louisianans, right? Or not on behalf of all of those in Louisiana. He's arguing on behalf of the people who are non-Black. And
That's what I'm
how are
saying.
you representing but you're supposed to be representing, to your point, the entire population in Louisiana. But you're now fighting on behalf of those who are not Black. And this is how I do believe, in my opinion, other groups of people who come to America and they get into our governments, they get into our, positions of authority and power, and they essentially try to maneuver power away from majority populations like Black Americans so that they cannot get any footing in their legislative bodies to actually demand any type of, recourse or redress or any type of
Well, just so that they
representative.
could listen, girl, listen, and I mean, I'm sorry for
You know what I'm saying?
interrupting
They can't
you
operate as
because
citizens. That's how I feel.
you are hitting the nail on the head, and not only, but it's one of those things like you come to my house and you mad, my grandbabies was over here. They spent a couple weeks with me, and they had they brought the little chocolate milk, and they were like, I want to put this little chocolate milk, So you come to my house, and because I got chocolate milk, you want to come through, suck up all my chocolate milk, okay? Get mad at me because I just so happen to have some chocolate milk up in through here, and I need to apologize for you because I got chocolate milk, and
right.
this is that whole approach from my perspective, So you want to come through, push us out the way, and then say we don't need to because you get to have Caucasian on your ID and be considered that in every aspect of the benefit recipient, and then push us out of the way so that you can have your piece. So now
And I would have brought that up. I would have brought that up in court. I would have asked him, how does he present on his ID, and what is what is his race identifier on his ID, and is he, and then who is his political party that he is. Matter of fact, we could look that up now. Benjamin Agua
Netanyahu. While you're looking that up, I'm going to go ahead and keep so we can hear some more from Anita Baker. Let me keep running this so we're on time and on track. You look that up and let me know when you got it, and then we'll just keep moving from here.
This court's dedication to eliminating all racial discrimination, it is that the Constitution does not tolerate this system of government-mandated racial balancing. I welcome the court's questions.
Why did the state of Louisiana switch?
If I was a court, I would say, sir, what positions you to talk about race? Because let me see your ID. It says what on there? Okay, white. Oh, okay, yeah. You're not. Go back and send me somebody that can really. I'd rather be a white man because at least you're gonna get his full. You're gonna get all of it. If he's racist, you're gonna get all that. I think one thing that our good friend Trigger Trouble, the Oracle said before. She said, I'll run my money across town directly to the racist before I run it to the middleman, because at least I know that the racists don't like me. You know what I'm saying? Let's keep it moving.
Sides since our last argument.
Your Honor, we told the court at pages 1 and 2 of our original opening brief in this case that our predicament in this case presents as good a reason as any for the court to reevaluate its voting precedents. We told the court at page 18 of our original reply brief that we thought this would be a different case if the court thought it was worth revisiting the longstanding assumption that compliance with Section 2 is a compelling interest. Your Honor, we thought all along, and in my colloquy with Justice Kavanaugh back in March, we discussed our longstanding position in our state legislative map litigation, where we have taken the position that Section 2, insofar as it requires race-based redistricting, is unconstitutional. This court's re-argument QP squarely tees up that question, and so our duty of candor requires us to give the court our honest answer to that question.
Let me jump in here and say this. The civil rights movement was strictly race-based. And this is why we have immigrants that are able to come in here and take advantage of all of these rights and benefits and things of that nature because of the fight that we put in, and it was based on race. So once again, it's the bamboozlement and the hoodwinkingment of everybody, because now that we've opened the door and we fought and we've paid the price, these people have come in, put their foot on their neck, and now you're trying to tell us we don't need race. It's not about race anymore. This is ridiculous. Let's keep moving.
Well, the race-based redistricting that you're now objecting to is redistricting designed to remedy a specific, identified, proved violation of law. More, a specific, identified, proved racial discrimination by the state. That's the way in which the race-based districting is coming in. It's coming in as a remedy for specific, proved discrimination on the state's part. How could that possibly fall subject to the categorical rule that you're suggesting?
Your Honor, I respectfully but firmly
Good
resist
question.
the premise that this comes to the court on a finding of specific discrimination by the state. I think if anything is clear about how Jingles plays out on the ground, it is that once you run the three preconditions and get to the totality of the circumstances, it's anyone's guess what the alleged violation is. I mean, I think Justice Thomas is calling...
General, I mean, what Jingles does, and, you know, the idea that this is like 50 years later, this is not a kind of Shelby County thing. Where one could say that Congress had acted and 50 years later, you know, the conditions on the ground might have changed and there would be no way to respond to that change. Because what Jingles does and what these Section 2 suits do is they ask about current conditions, and they ask whether those current conditions show vote dilution, which is violative of Section 2. So they say, is there racial segregation, racial residential segregation now? Is there racially polarized voting now? And when the state fails with respect to those issues, when those conditions obtain now, what our precedents say, and what you're asking us now to change, what our precedents say is that when those things operate currently, right as of now, and are proved in a courtroom, that that still there can't be a race-based remedy.
That's correct, Justice Kagan, and I think the two trends that my friends on the other side point to, the rates of residential segregation and the rates of racially polarized voting, are what allow them to get past the Jingles preconditions. They told you at page 33 of their yellow brief that those things are worse today in Louisiana than they were in the 1980s, and this court said at page 228 in Northwest Austin that those sorts of factors are not evidence of intentional discrimination. That's not intentional discrimination.
It's not intentional discrimination because Section 2 is not about intentional discrimination. Section 2 is about effects discrimination, is about Congress saying, and specifically in response to a decision of this court, that intentional discrimination and the values behind that prohibition can only be vindicated if Section 2, under Section 2, the state shows that the effects are not discriminatory. And, you know, Congress put us, this court, in its place when it said that. And so what Section 2 does is to say where the effects are discriminatory, such that people are not having the same, African Americans here are not being given the same voting opportunities as white people are, then a remedy is appropriate. That remedy doesn't have to be race-based, but sometimes it is race-based in order to correct the racially discriminatory situation that exists in the state right now.
And Justice Kagan, if Congress had attempted in 1982 to make a record of intentional discrimination in districting, and today, if there were a record of intentional discrimination in districting, then there might be a congruence and proportionality argument to sustain.
So, He
Black,
said
you gotta.
if Congress had did something in 1982, then we'd have a record of X1. First of all, we can't go back in time, right? All you can do is move forward to fix the issues now. So bringing up the fact, had they done something, does not validate the fact that it's there for you to use so that you can go ahead and make your point. And then the second thing is, notice he was saying black residents, and she went off and said African Americans. I'm not going to make an issue of that. My problem is that yet again, the non-black people are bringing the case, but they're trying to argue against the fact that black people, even though they're the majority, and they're not being represented properly, you still can't use that as a reason to say that non-black people can't use race. Like it sounds so weird.
Well, if you also, she said, and was very, she said, but if whatever's happening, if the outcome is racial, it's discriminatory, then it has to be addressed. Let me see if I can swing that back just a little bit. And welcome to the stage, Black Majority. Let me see if I can get to where she said that again. Hold on.
Opportunities as white people are, then a remedy is appropriate. That remedy doesn't have to be race-based, but it's not intentional discrimination because Section 2 is not about intentional discrimination. Section 2 is about effects discrimination, is about Congress saying, and specifically in response to a decision of this court, that intentional discrimination and the values behind that prohibition can only be vindicated if Section 2, under Section 2, the state shows that the effects are not discriminatory. And, Congress put this court, in its place when it said that. And so what Section 2 does is to say where the effects are discriminatory, such that people are not having the same, African Americans here are not being given the same voting opportunities as white people are, then a remedy is appropriate. That remedy doesn't have to be race-based, but sometimes it is race-based in order to correct the racially discriminatory situation that exists in the state right now.
And there should be an expectation that the solution, that the cure would be race-based. To approach something this significant and think that black people aren't going to say, hey, wait a minute, you did something by redistricting that cut every black American, every melanated person out of the ability to take advantage of the same voting right that your ass has. And then to all of a sudden cry foul and say, well, we don't see race. But you saw enough race to specifically cut out all the race. I guess you don't see race now. You cut them all out. Black, what's up? How you doing?
Hey, can you hear me?
Very well, sir.
Yeah, so in other words, they can use race to harm another race, but they can't use race to help the race that's been harmed for 100, well, more than 150 years, 400, 500 years at this point. I noticed that she said African American, and he said white people. I swear you gotta watch these demons, man, and they're not confused. Those questions they're asking, if you really rewind the tape, they keep asking the same questions, and their questions are informative because it's telling you what they actually want to accomplish. The only reason why they're asking those questions, and they keep trying to catch different people up. Now they got this is their boy. You know what I'm saying? He came to give them everything that they can't say, even though they're saying a lot.
And he's a Republican.
Oh, no question about that.
Yeah.
The other thing about these districts are like over 700,000 people. I think there's 750,000 people. So when a small group of so-called voters can bring this type of suit and disenfranchise potentially hundreds of thousands of black Americans, that part is also disgraceful. So I'll land with that.
Yeah. Yeah, yeah. And this guy's so happy to be arguing this case, and but I wonder how he feels. Like, does he see anybody being engaged with ICE, and does he feel a type of way? Because that's what I'd like to ask him. How do you feel about ICE right now?
Yeah, and I'm wondering if the population of the non-black voters that are bringing this case, I wonder what the majority of them look like.
Mm-hmm. I do too.
Hmm.
Because I bet they don't look like him.
Or they do, or what if they do? Because I'm wondering if that's how they took control over California.
Good question. They may. They very well may, but we're talking about Louisiana, so and I don't know, but either way, this guy's a token. That's all. That's what I think. He's on some token time right now. Let me keep rolling with the tape.
And Justice Kagan, if Congress had
Conquistador.
attempted in 1982 to make a record of intentional discrimination in districting, and today, if there were a record of intentional discrimination in districting, then there might be a congruence and proportionality argument to sustain race-based redistricting as a remedy. But I think something that you don't see in the congressional record in the 1980s and something that doesn't exist today is that justification. And that's
I'm
why
sorry,
I think,
counsel. That's because they weren't dealing with the history of it. They're dealing with the current situation. Gingles is, as Justice Kagan pointed out, what's happening today, and are there lingering effects of the past? The one thing I look at is Alabama's maps for the last 30 years. The map that the Robinson Court found, cracked and packed voters, was a map that's been in effect almost the entire history of Alabama.
Oh,
That
wow.
map was put in effect because of discrimination. So it's going to have a lingering
He should have just
effect.
said it. Slavery.
They wanted to pack white voters. They've been doing that. And they wanted to uncrack black voters as much as they could, and they've done that. And it's only Section 2 and Section 5 that kept them creating one majority district. But using race is a part of redistricting always. We've said that the only actionable part that's intentional if it predominates, but race is always a part.
Oh, snap. What had happened was, oh, shoot. Can you guys hear me?
We can hear you.
Hello?
Can you hear us?
Rella?
I'm here. Can you hear me? Hello? 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 Hello?
Hello, I can hear you both, but I think only Mel
I can
Cruz
hear
went
you
Rella?
off.
now. Can you hear me, Black? I can hear you.
Hello?
Yeah, I can hear everybody. Can everybody hear me?
I don't think Mel can. I can hear you. I don't think Mel can hear us. Let me see. Ooh.
Hello?
Can you hear us, Mel?
Okay, I don't know what had happened but we're gonna go ahead and wrap this up because for whatever reason,
Can you hear us now?
apparently,
Mel.
I don't know. I don't know what's going on. Can you guys hear me out here in the YouTube streets? Can y'all hear me?
We can hear you.
Can y'all
We
hear
can
me?
hear.
Oh, it's just not playing. Can y'all hear me? Nope.
Yes.
Yeah.